Good afternoon, everyone. Thanks for being with us for this webinar this afternoon. We are going to get started. I have just a bit of housekeeping and some introductory notes here for you. We are still letting some people in through the waiting room, but it looks like we have critical mass for the most part. I wanted to say good afternoon to everyone and thanks for being with us. My name is Leah Landry. I am the Advancement Coordinator for Massachusetts Association for Mental Health. On behalf of MAMH and the Massachusetts Aging and Mental Health Coalition, we want to thank you for joining us this afternoon for this webinar, Preventing Evictions for At-Risk Older Adults. It's really an important topic always, especially this month, as May is both Older Adult Month and Mental Health Month. In 2019, half the chronically homeless in the United States were between 51 and 60 years old. And if you look at trends over time, the median age of individuals who are chronically homeless is likely to increase, as the same cohort of individuals is likely to remain chronically homeless into their 60s and 70s. This webinar's aim is to teach you about the problem of housing instability and eviction for low-income older adults in Greater Boston, plus how to tell if someone is at risk, legal rights of tenants, available resources, and much more. Our presenters will be sharing all of that information in just a moment, but I do have some housekeeping items for you. I, along with my colleague Jennifer Erf, will be providing some technical support throughout this webinar, so you may hear from us at times. I have a few reminders for you to start out with. This webinar is being recorded. It'll be made available at a later date, and recordings will be sent to the email that you used to register for the webinar, so keep an eye on your inbox. The presentation portion of this webinar is going to be about 45 minutes. Presenters have left 15 minutes for questions at the conclusion. To ensure that everyone is able to hear presenters clearly for that presentation portion, we have muted all participants. That being said, if you'd like to ask a question, use the chat box. During the Q&A period at the end, we're also offering the opportunity to ask a question in real time. Maybe if your question is complex or you'd prefer to ask it directly, you can raise your virtual hand, which you can actually find by clicking the reactions button on the bottom of your screen. We'll try our best to fit all of your questions in. To start us off, I want to introduce our moderator and first presenter, Eileen O'Brien. She's been working on behalf of underserved and marginalized older adults for 40 years. Since 1988, she has been the director of Boston Medical Center's Elders Living at Home program, which supports homeless and sorry about that. She's been the director of Boston Medical Center's Elders Living at Home program since 1988, which supports homeless and at-risk older adults to transition to and maintain safe, affordable, and permanent housing. So I'll stop sharing my screen now, and Eileen, the floor is yours.
Thanks very much, Leah, and thanks to you and Jennifer and MAMH for providing technical assistance for this webinar today. We really appreciate it. As Leah said, it's an important topic to talk about preventing evictions for older adults. She touched on the fact that homelessness is a growing issue for older adults, not only in Massachusetts, but throughout the country. And I'd actually like to spend, before we get started, a few minutes talking about a particular aspect of homelessness that maybe you don't always think about, but it gives you some context into what I fortunately have never been homeless. I am very blessed to say that, but it perhaps gives you a little bit of an insight into what it might be like. What challenges homeless people face? and why it's important to prevent evictions and keep them safely housed. So I'd ask you for just a minute to think about the space that you live in. A little bit easier today, maybe for some folks, because a lot of us are working from home and are actually in the spaces that we live in. So maybe take a look around and see the things that are around you in that space that you live in. There probably are pictures of loved ones, other sorts of mementos. Maybe you have pets. I have a couple of cats who may be roaming around in the background here. Things that you use to practice your various hobbies, maybe a musical instrument or, painting or something along those lines. Maybe mementos, things that you've saved from trips you've taken. And all of those things are around you. And in one sense, those things are merely belongings. But on the other hand, aren't they in some ways a part of what makes you the person that you are today? Those things that you have around you, the photographs, the memories, the pets, the seashells you picked up on the beach and that vacation you took in the before times when taking vacations were possible. And you think about what it might be like to be separated from those things if you didn't have a place to live, if you were living in a homeless shelter where you only could keep the things that you could carry, or even in a nursing home where you're limited to what it is you can have in your small space in the nursing home, and how that might make you feel if you didn't have those things around you, and how that might even make you question, am I still the same person if I can't practice my hobby, if I don't have those memories around me, if I don't, if I don't have my cats to bug me during the webinar, am I still the same person? And, think about that for a minute and what kind of an impact that might have on you a little bit. And that's why we're here, because for older adults particularly, a lot of those things are very, very important. We want to make sure that people have access to everything that they need to feel whole and feel themselves and remember who they are. So we're here to talk about this important topic of preventing evictions for older adults. I'd like to introduce you to Betsey Crimmins, my longtime colleague, who's a senior attorney at Greater Boston Legal Services, who's going to give us the legal perspective on preventing evictions for older adults.
Thanks so much, Eileen. Thank you for everyone who's attending today. I agree with Eileen. It's a really, really important and timely topic, unfortunately. So I am a senior elder law attorney at Greater Boston Legal Services. And pre-COVID, a good portion of my work has been what I call eviction prevention work. Since last summer, we made a decision to do nothing but eviction prevention work in the elder unit, just to respond to the housing crisis that we're currently in. So I'm going to go over the process a bit, and I'm going to be really careful not to get lost in the weeds and take up too much time. But I would just want to start by saying we're very lucky at GBLS to work with 5 different ASAPs, Aging Service Access Points, also known as Area Agencies on Aging, along with countless other social workers, council on aging staff, case managers, helpers, all of you who are crucially important to the work that we do, which, as I said before, I call eviction prevention work. So I think it's really important to try to stop an eviction, but I think it's more important while you're doing that to try to preserve a tenancy long-term for anybody, but especially for an older adult who's at risk of becoming homeless and chances are never getting back into affordable or subsidized housing again, having increased hospitalizations, a premature institutionalization in a nursing home. In other words, nothing but really grim outcomes. So the work we do is really important. And I can honestly say I could not do my work without the help of the kind of people from the ASAPs and all over the aging provider network. So I am going to very carefully try to share my screen and go. I just have a couple of slides on the legal eviction process. I think it's really important that everybody understands that a tenant has a right to a legal eviction process. So let me hope this comes right up. Hope everyone can see that. So this is really the most important slide, and everything comes back to this, which is a landlord can start the eviction process and a landlord can see it through with the various steps, but only a judge can evict. And that's important because we get calls constantly, whether it's from older adults or from people trying to help older adults who say, and I'll just read one I got today. The notice they got, your rent being in arrears. You are hereby notified to quit and deliver up at the expiration of 14 days. The premises now being held by you, or you have to be out by June 30th. That eviction notice, which is the first step, which is my next slide. Here it is, which is the first step in the process, often sends people into, just terrifies people because the notices are written in a way that makes people very reasonably think that they actually have to vacate the apartment by that date. So again, if there's nothing else you remember from these slides, it's that that is not true. That is the first step in the legal process. Because I've just seen so many people pack up and then move out by that date to unaffordable places, to unsafe places, to, just put their stuff in storage and start to stay on people's couches when, in fact, if they had had some help and seen the process through, they might have been able to hold on to their tenancy. So that's just really important that that date simply is, now on to my next slide. After that date, it simply means the landlord could go to the next step in the process, which is called a summons and complaint. So this is a form that's generated by the court in which the case is filed, and it gets served on the tenant by a constable. And pre-COVID, this notice, the summons and complaint, would have the court date, the court time, the name of the court, the landlord's name, the attorney's name if the landlord had an attorney. During COVID, so right now and into the foreseeable future, the notice says, I wrote this down somewhere, it says summons and complaint on the top, and it looks similar to the old notice, but it doesn't have a date. And this is important. Instead, it says the court will send you a notice of the date, time, and manner of your court event. So it's really important if you're working with somebody to say, keep your eyes peeled on the mail because you are going to get a notice. And we've had people who've gotten their notices on a Friday and the hearing's on Monday. And it's going to have the date, and you need to share that information with me right away. In both cases, pre-COVID process and now during COVID process, the tenant has a right to file an answer. And this is really her opportunity to counter what the landlord put in his or her notices, in the notice to quit or in the summons and complaint. So basically, what's your story? How are you able to say, I should not be evicted? And legally, that's called being able to make legal defenses or legal counterclaims. So again, if you just leave by the quit date, you've missed out on this whole process, which is both important because you might be able to retain your tenancy. And even if you're not, this process takes time. And sometimes it's the time that's most important for someone to get to their next best place. Just another note about the COVID changes, that first event when you get the summons and complaint is now called, it's not a trial date, it's called a first tier event. And I actually really like this new process because it's an opportunity to meet with the landlord and his or her counsel if they have them, and with a housing specialist. And it's really designed for a couple things. One is to try to mediate, just to talk through and see if there's a way to settle the case. It's also an opportunity that some housing specialists do and some don't, unfortunately, to let tenants know about additional resources. So I think the resources are going to be posted in the chat. There's a bunch of different websites out there, but one of the resources is there was money from the state to set up, we call it KELP, the COVID Eviction Legal Help Project, which brought a bunch of new attorneys, paralegals, and intake workers all over the state to help people through this crisis. It was initially funded for 6 months, and it's been extended for another 6 months, so it should run through most of 2021. There's rental arrearage money, and that's in the KELP website. There's right now a federal eviction moratorium that's in place through the Centers for Disease Control, and that is set to expire at the end of June. That's only for non-payment cases, but we've seen plenty of older adults with non-payment cases over the last year. And I also put another, I think this is a really, really great tool. Joey and I have a former colleague named Quentin Steenhouse, who's now at Suffolk Law School, who created a program that anybody could use, whether it's a tenant or a helper, to create the answers and the discovery documents. And it's really sort of a step-by-step easy process, and it's a great response for tenants who are unrepresented. So I just want to say this, I look at the housing court list every single week, and what you pretty much see, and this hasn't changed even with the additional resources of KELP, is almost every landlord has a lawyer and nearly every tenant does not. And that's how it's always been, and that's how it continues to be. So tenants are at a distinct disadvantage going into a housing case, into an eviction case without legal assistance. MAID and some of these other resources help to level the playing field a little bit. So to the extent you're able to share these resources with tenants you're working with, that would be terrific. Have one more slide, there we go. So this is my last slide, and I think it's really important to know about reasonable accommodations as a potential defense to an eviction. I think when people think about reasonable accommodations, the first two bullets are really what they think about the most. So someone who needs to use a wheelchair and needs a ramp in order to get in and out of their house or apartment, or somebody with a service animal who moves into a building that has a no pets policy, and the accommodation is to allow them to bring the service animal in despite that policy. It's really the last bullet, though, that almost all the cases that I work with, especially people with mental health or behavioral health diagnoses, we utilize. And this is always with somebody from one of our community partners. It's very rare that I'm able to create a service plan on my own without the assistance of a social worker, a protective services worker, a case manager. So what does that look like, and how can you all help in this process? Because there's plenty to be done to help tenants, even if you're not a lawyer or a legal advocate, through this process. And I can tell you, especially during COVID, so many of you have stepped up and attended first-tier events, used MAID to create the legal documents, and really, really help people keep roofs over their heads. It's been a really amazing response. But just briefly, I'll use as an example a person with a mental health diagnosis of a hoarding disorder. And I might go visit the person because they've gotten a notice to quit saying that they are in violation of their lease, in violation of the state sanitary code. And I enter the unit and I look around and I say, yep, absolutely. This is a very big lease violation. There's some safety issues, there's some health issues. So the request for reasonable accommodation is not to say to a landlord, listen, this tenant has a disability of hoarding, therefore you should allow her to continue to remain and not alter her behaviors in any way. That can't possibly be the accommodation. The accommodation really is about time. It's, can you just stop this eviction process, just halt it for a while, and give me as her lawyer or give me as her social worker some time to create a service plan. So what might she need? Some mental health services that come right to the apartment, working with a hoarding specialist, heavy chore services. All of those things get pieced together in a service plan. And then the time to get the service plan operational. So the first thing you do maybe in the first week is get rid of all safety hazards, papers off the stove, create an egress wide enough to meet the state sanitary code. And once that's able to be done, then other things may move more incrementally, but that's the plan. And the person's not evicted as long as they're adhering to the plan. And these work. Obviously, having the tenant participate is crucially important, but being able to get that time to get that plan together is really important. If you can get all the pieces together, you can not only, as I said, prevent an eviction, you might really be able to get somebody who's got perhaps an untreated, undiagnosed, and unacknowledged mental health or mental health issue, which is at the root of the legal problem, get them the real help that they need. It's not just a clean out once every couple months, it's mental health services, it's case management services, and it makes a really big difference. I think I'm going to now pass this over to Laura and Joey, and they're going to illustrate some of these issues in more detail. Thank you.
Thanks, Betsy, and thanks everyone for attending, and obviously to MAMHC for having us here today. My name is Joey. I'm an attorney in the housing unit at Greater Boston Legal Services, Betsy's colleague. I think what we were asked to do is talk about sort of a typical way that some of these issues play out in the eviction defense context. I can tell you right off the bat, there's no sort of one way all these issues play out. I think every case is different. Every case is complex. I think one trend that I would point out right off the bat is I think elder issues or elder evictions really bring to the forefront, I think, some of these broader structural patterns that Eileen and Betsey were talking about at the outset of their presentations. I mean, obviously, skyrocketing housing costs in really all across Massachusetts, not just Boston, but especially Greater Boston. The overall lack of underlying legal protections against, speculative rent increases, no-fault evictions, other evictions that are essentially fueled by gentrification in a lot of urban areas in the Commonwealth. Obviously, the harshness of our system upon folks, certainly with mental health needs and other disabilities. I think another piece of it that we need to talk about and that we should be thinking about is race as well. Obviously there's a lot of research about, the enormous wealth disparity between, Black folks and white folks in Massachusetts. The stuff that the Globe put out recently about how median wealth for white families is $250,000, median wealth for Black families is $8. Obviously, as people age, that plays a role in why, especially given that there's also research about racial disparities in where evictions are filed in the first place, right? How the burden of that disproportionately falls on Black elders. So I think the other sort of, if there's another sort of truism to keep in mind, it's the importance of collaboration with community organizations. I've had the privilege of working with Eileen and Laura, elders living at home in a lot of cases. Some organizations on this call, elder services groups in Greater Boston, MVES for folks in Revere and Chelsea, where I do a lot of my work. So I think, and Betsy spoke to this too, the importance of coming up with an approach that's not just legal, right, but also case management focused and how important it is to work together. And I think the case that Laura and I are going to talk about really plays this out because, it started, so my work tends to be focused on these no-fault evictions in gentrifying parts of Boston. I don't exclusively work with elders, but, to the extent that, elders come to, to us or the community groups that we collaborate with, saying my rent's getting raised, my building's getting sold, my whole building is getting cleared out by an investor, what do I do? We certainly represent and support elders in that context as well. And the case that, we're presenting sort of started out in that paradigm. Oh, it's a no fault eviction. You know, starting out by explaining, you know, you have the right to file an answer, you have the right to defend yourself. You know, in many circumstances, if a tenant does know their rights in that situation, in particular, the ability to counterclaim the landlord for any violations of the law they've committed over the course of the tenancy, bad conditions, retaliation, stuff like that, you actually have a lot of leverage to potentially either negotiate a lot of time to move, or even by agreeing to waive those considerable counterclaims, stay in your home, or you know, negotiate a way to lease up for a certain amount of time. And so initially, I had a case involving an elder in Eggleston Square, which is a rapidly changing part of JP Rocks, or JP and Roxbury in Boston, where again, I think it started out as one of these boilerplate cases. Okay, you lived there for a long time, your landlord's not done a great job with maintenance. We're able to connect you with other neighbors in your building who are also getting evicted. We can definitely, you know, litigate this case in a certain way and you know, potentially keep you where you're at. However, over the course of the case, so she was, at the time we first started representing her, she was 70 years old, had tremendous complications from a prior diabetes diagnosis that actually resulted in her losing part of one leg and then some toes on the other, having to have surgical amputations. And she happened to live in a third floor walk-up. So immediately it sort of morphed, right? From a case where, you know, again, you're approaching it with this sort of litigator hat to, well, we need to come up with some kind of solution that's more holistic here. And in particular, you know, where is the value of winning an eviction case, right? If what you ultimately win is potentially keeping her leased up at a place where it's wildly unsafe. It's a third floor walk up where she's not able to get around. She's not able to get up and down stairs without assistance. So, you know, at that point, like I said, the collaboration with agencies like Elders Living at Home becomes really that much more important. And I connected with Laura, you know, unfortunately, pretty far into the life of the case, because housing search supports for folks living in private housing is limited. Housing search options, even for elders, are ultimately limited. As Betsey mentioned, there's a huge affordable housing crunch really across the Commonwealth. You would think that someone who is living in a third floor walk-up who is over 65 and is missing part of a leg, well, that's a no-brainer, right? They can just get on a waiting list and be placed in a matter of weeks, right? No. You know, you get on a priority category, and even those priority categories often take a year or more to move. And so anyway, I'm going to pass it to Laura to talk a little bit about the case management and housing search aspects of the case. But thanks again for your time, and yeah, appreciate you being here.
Thank you, Joey. I just, as a case manager, and I've been only doing this for about 7 years. I worked in home care for years and years and years before that. But really, if you do any sort of work in eviction prevention as a case manager, connect with GBLS and HLAB and all these great organizations, because they will make your job so much easier. So Joey had actually connected me with this elder to start doing housing search for her, as her income was relatively high considering some of our clients, but still she needed a subsidized unit. So we started with that. But the first time I met her was at her apartment. There was obviously some issues going on with hoarding, despite the fact, I mean, even putting aside the fact that she's in a third floor walk up and she has an amputation. And so she also was having some issues with paranoia. She thought people were coming into her apartment and touching things or breaking things. She mentioned to me that there were holes in the walls, that people were seeing or hearing things. So there was that. There was the fact that she was in a third floor walk-up, that she was in the process of being evicted, that she needed a subsidized unit, and she obviously needed home care services. She has a daughter who's very involved, but the daughter also works full-time and has her own stuff going on. So we were able to start the housing search process. She had already been on a list for some subsidized units through a housing authority. And she had priority under that. And at the same time, she also needed to get some home care services in to help start doing some cleanup, personal care, things like that. She initially resisted a lot to get home care services, but we were able to get a great intake case manager to come in, and I was there and Joey was there and somebody else from the community was there to encourage her to receive services, which she did. But then this all happened not too long before COVID hit. So she sort of reluctantly agreed. A personal care worker came in, and then COVID hit and she didn't really want anyone in the apartment. Luckily, her daughter was able to come in and start sort of doing the clean out of the apartment, because at least when we went for the initial visit with the intake case manager, Joey was 4 of us, 5 of us maybe, in a very small area in front of her front door, trying to do an intake, which if you're a home care case manager, you know how long that takes, doing an intake with really no space at all. So there really was a lot of clean out that needed to be done. And so the apartment's been getting cleaned out. She's still not willing to accept in-home services currently, but she is doing pretty well. And she actually there's actually a good ending to this, because she actually has gotten to the top of a list where they're hoping to have her move in maybe in June or July into a brand new, and this almost never happens, brand new handicap accessible unit, which is great, but it's been a long haul. Joey, how long have you had the case? I've been involved a year, so.
A year past that, we first got her on priority 1 with housing authority. And before that, I'd had the case for a year and a half.
Yeah. So it's just, and I think people think that, as I think Eileen had said that, and Betsey, that you can just, that no one is going to ever evict somebody who's elderly. And I actually had another case a few years ago where the client said to me, well, my case manager told me that they don't evict people that are elderly. And I said, who was it? And it was actually an old colleague of mine, who I then went to and said, it happens every day. So it's not, and there's no, as we all know, that there's no emergency housing, certainly in the city of Boston, or really anywhere in Massachusetts. It's just shelters at this point.
Well,
go ahead. No, go ahead, Eileen. Sorry.
Do you have anything to add, Joey, at this point?
No, not to the end of that excellent summary of what happened. I would only add that, the happy ending is even happier than what Laura said, because the new building is like a mile down the road from her current place. So
that's great.
We're going to be able to keep her in our community. But it is, I think, both in the private market context, which this case was, and the subsidized housing context, where, you don't typically see the rent increase issues, but, oftentimes there are very, very complex issues around, managing, mental or emotional or physical disabilities, and helping people facing those challenges comply with their lease in the face of, what can at times be, very aggressive approaches from management companies and landlords attorneys who should be better versed in state and federal anti-discrimination law than they often are. So I think in both contexts, you need a really collaborative approach, and as I said earlier, a holistic approach that thinks about it, not just from the perspective of, here are sort of the legal claims and how the facts map onto them, but also, the human issues, right? Like building trust with someone who, for a lot of legitimate reasons might take a while to do, right? And making sure to lean on folks with clinical expertise, right, as well as the legal expertise to reach the right outcome for people. So, thank you.
Thank you to Betsey and Laura and Joey. That was all really helpful information. we'd like to open it up to questions now, if anyone has any questions. I did see one come in the chat box. How did the court and landlord deal with the lengthy process? This must be for Laura and Joey, to answer about how
I mean, I think, so, I mean, in this instance, they've been both been very accommodating. I think I think COVID sort of really scrambled things, you know, in terms of what happens in the litigation. We settled it like right before COVID and agreed to a move out date with the understanding that it could be flexible, but, you know, flexible sort of took on a whole new meaning when the pandemic hit, you know? I would say it's very much not the norm for, you know, an eviction case to carry on for almost 4 years. I think the fact that this one has is a testament. I mean, you know, I think the landlord in this case has acted admirably and been very patient and understood the equities, but I think we also got to that point because, you know, we did our homework at the beginning of the case and presented a really vigorous defense, and convinced the other side that it'd be worth their while to be this patient, right, as opposed to taking a different approach. I think the norm is not typically that forgiving, and you know, what Betsey said is really, really important, which is that although there are some specific protections at the back end of the process for folks over 60, you know, if you already lose your case, you can ask for more time in certain circumstances, and if you're over 60, you can get up to an additional year before you can be physically moved out from your apartment. You know, getting that much time is very unusual if you have not, at the beginning of the case, acted proactively to you know, make sure that the tenant is invoking all their legal rights, filing an answer, as Betsey said, and, you know, again, making sure that they have access to both counsel and social services that can either facilitate a good resolution to the case in their current spot or facilitate a stable transition.
Great, thanks. There's an earlier question. If an individual has, and this is for the lawyers, I believe, if individual has a chemical sensitivity, says he needs a unit without new painting or carpeting, is he able to claim that modification as a reasonable accommodation? Numerous housing authorities have already rejected this as a reasonable accommodation.
That might be a good one to handle offline, because you need a lot more information to even begin to answer that question. I don't know if my email is anywhere, but the person who posted that can feel free to reach out.
Betsey, can you share your email? I don't know that it's anywhere.
Sure, I'll put it in the chat.
Okay, great, thanks. The next question is, this is a Laura question, I think. How does one get a consumer on the priority housing list?
It depends on what priorities you're looking for. So do you want to put, I can put my email in the chat if they wanted to talk.
I can answer the different housing providers have different priorities. So it's a matter of finding out what the various, you know, for example, some housing providers, Boston Housing Authority, which we work a lot with at Elders Living at Home, you know, they have a priority for homelessness. They have a priority for rent burden. They have a priority for, you know, if you've been displaced by a fire or flood, if your accommodations are not accessible to you, those are their priorities. And it's up to housing providers to decide what their priorities are. So it's a matter of matching your consumer needs to what the priorities are for the particular housing options that you're looking for. That's probably the best way to do that. Next question is, this is a legal question. If a landlord wants to sell their property and the renter is an elder, can the sale be delayed because the elder seeks delays?
Yes. As Joey said, well, two things. One is the sale can be, you could go through with the sale, but the new owner inherits the tenant. So sale can still happen. If the elder's over 60 or is a person with disabilities, they can ask for and get, it's not automatic, it's within a judge's discretion up to a year. What I tell people is keep a log of every single housing search you've done, because you're supposed to be doing a diligent housing search during that time. Pre-COVID, a judge might have you come into court every month or every 2 months just to make sure you're still doing the housing search, but you can get extra time in a situation like that. If it's not your fault. So it's a no fault eviction, landlord selling the property wants you out.
Great, thanks, Betsy. Next question is, what are the best resources for someone who needs very hands-on help with finding housing?
I would love to know the answer to that question. I think housing search is one of the hardest resources to access because it's such a tight and expensive rental market, and we have a real lack of affordable housing for people in, I'm not even going to say Greater Boston, because I used to say, oh, try Revere. Well, no, not anymore. Or try Lowell or Lawrence, not anymore. Try the Worcester area, not anymore. So I think it's the entire state now. So I have worked with some, well, Laura's excellent. Laura's a good housing search worker. Worked with some housing search workers. Not all agencies have housing search. So it really is a resource that I think we need more of, but it's just difficult. It's a very difficult landscape.
If this person is in Greater Boston, Laura and her colleagues will not be happy about this, but I'm going to say go to eldersathome.org. You'll find a referral form and instructions on how to make a referral to us for someone in Greater Boston. Jennifer let me know that we will be able to email folks that we can't answer. The chat will be saved in Zoom, and we will be able to email folks that we either the answer is too complicated or we don't get time to get to during the presentation. So just so you know, we will be able to reach out to you post session today and answer whatever questions. I have a client who rents a room from someone, but there is no lease. She asked to leave by June 8th because the landlord doesn't want her there anymore. Can she be evicted?
I can take this one, Betsy, if you want.
Sure.
Yeah, so I don't know if what you mean by the landlord is the owner of the building or the master tenant in the room, or like the master tenant of an apartment. I think the answer depends sort of on who is the person saying, should he be evicted? But let's assume that it's the person who you're renting the room from who says, I want you out. If you have no lease, then, as Betsy said, you have the right to an eviction process. The way that process is initiated is by service of what's called a 30-day notice to quit or a rental period notice to quit. That means that you have to get a letter from the landlord that says you need to be out at least 1 month or a full rental period, whichever is longer, which is typically the full rental period, before you can even start a court case. So in other words, we're in May, assuming that rent's paid on the 1st, if you give someone an eviction notice now, the earliest it can expire is the end of next month, at the end of June. If they try to move forward with a court proceeding before the end of June, that is before July 1st, then it could be dismissed. So the answer is yes, but there are rules that they have to follow. And moreover, the person being evicted has the ability to raise counterclaims against the landlord if the landlord's violated laws during the tenancy that they might be able to use as leverage to get more time. So yes, they can be evicted if what you mean is, can an eviction process be started? but there are a lot of ways to leverage the legal process to get more time such that they can certainly get past June 8th.
In other words, she doesn't have to be out by June 8th.
That's correct, yes.
Next question, does the Americans with Disabilities Act protect tenants with disabilities from facing eviction? For example, someone with a hoarding disorder is facing an eviction. Are they protected under that act?
No. Simply because you have a disability. I mean, this sort of goes, it's in line with what I think Eileen and Joey mentioned before, that unfortunately some people think they can't be evicted. And I've seen people who are of a certain age who just think they can't be evicted, which unfortunately isn't true, and people with disabilities as well. So simply because you have a disability doesn't mean you can't be evicted. What it does mean, and I think this was my last slide, is that you might be able to raise as a legal defense in your eviction case or a counterclaim the fact that your landlord has not reasonably accommodated you. And it is a more complicated process than that, but it doesn't mean you can't be evicted, but it does allow for you to try to create a reasonable accommodation defense to your eviction.
Thanks, Betsy. Our next question is, oh, this is not a question, but a comment. Thank you for sharing and explaining how I can move forward with a person who is being evicted due to hoarding. Mental health is seemingly becoming a reason for eviction when medications need to be changed. Couldn't agree with you more. What resources are available to housing and/or residents to try to mediate these concerns, especially issues with appropriateness of housing before it enters the court, or does trying to do so put the housing at greater liability for doing so?
I think that's a really interesting question. I don't know that there are any pro bono or free mediation resources available. In public or subsidized housing, if you get a notice to quit, you often have a right to what's called a grievance hearing or a termination hearing, where basically you go down to the office or you sit in some conference room and talk to the property manager or the head of the housing authority. That's not really mediation. That's it is an opportunity pre-court to try to work things out. As I mentioned before, what I like about the new legal process right now is having a first tier event before a trial. You're not even in front of a judge, you're in front of a housing specialist. And that step is designed to try to mediate and work things out. In the housing courts pre-COVID, there are housing specialists where you have a chance to go mediate, but both parties have to agree to mediation. There are free court mediators available in most courts. And mediation can be a great tool, but again, a tenant who's unrepresented, and I don't even just mean by a lawyer, if somebody else is with them, a social worker, somebody who can just help them through the process, it levels the playing field a little bit, but even mediation is stacked against a tenant where the landlord has a lawyer. That's my 2 cents.
The only thing I would add to what Betsy says is if it's a non-payment case, there are some, in addition to the expansion of access to counsel for COVID affected tenants that started right around the time the eviction moratorium ended in late October, there's also an upstream mediation program that the Department of Housing and Community Development is funding. And I'll be honest with you, I've not had a case make it to one of those mediators, at least not upstream, that is before court, since the moratorium lifted, but that is at least an option in theory. And I can look in the chat, or I can post in the chat if there's any website or information about those. You might want to just reach out to those agencies directly if there's a particular case where it might be a good fit.
And I just had one thing on that is just if somebody does go and reach out to the management company and sit down with their client and the manager to sign any sort of agreement, just make sure that the person can follow through on the agreement, because I've seen so many where someone will sign something saying that they can do it and they just can't, whether or not it's behavior issues, whether or not it's back rent, whatever. Just make sure that the person actually can follow through with the agreement.
Thank you. Does the housing court have a hoarding specialist who can work directly with elders? That's a great question. Anybody?
Well, no, not really. So there are some great resources at the housing court, TPP, the Tenancy Preservation Program or project. I forget what the last P is. There is one person in particular that I've worked with out of Northeast Housing Court who works really well with people with hoarding disorders, but that's not really her role. There are hoarding specialists out there. A lot of times my clients are only able to access those services if they're working with protective services, so that the ASAP will actually pay for the service because there's a charge. And with low income tenants, being able to pay for those types of services is not an option. So as important as it is to try to not just go in and grab people's stuff and throw it into a dumpster, but to really try to do it in a way where, as I said earlier, you're going to try to preserve the tenancy, sort of fend off the eviction, preserve the tenancy, have services ongoing for as long as they're needed. That's sometimes a lot easier said than done. But I do think the ASAPs are very aware of the fact that hoarding is a very prevalent problem, and oftentimes at the root of a lot of the eviction cases we work with. The earlier you can intervene, the better, but a lot of times it's the only way somebody knows that an apartment has a huge hoarding problem is because something happens. Somebody trips and EMTs can't get in, or there's an inspection and it's discovered. It's not something that, oh, it looks like this is a developing problem, let's intervene now. It's almost always very reactive and last minute. And it may be something that someone's been doing for decades. So it's a very difficult disorder to work with, and you really do need specialists. And that's not what Joey and I do. We don't have any of that sort of training. And as I said earlier, working with people in the field who have social work degrees, have mental health training, have specialized training is crucially important for our work, and to sort of work as a team and each of us in our own lanes doing what we do best. And I think that's the best way to really preserve a person's tenancy going forward.
Thank you, Betsy. So this is I know this is a common issue, people waiting on Raft applications to be approved and they owe back rent and they're going to be evicted for non-payment. Does the court factor that in? That the wait times can be long for Raft?
Yes, so the legislature passed a limited eviction protection as part of the last budget session at the end of 2020, called Chapter 257 of the Acts of 2020, under which if you have a non-payment case where the arrearage was either caused by or exacerbated by the pandemic, and you apply for a rental assistance program, either state or local, before the trial date, not before the first court date, which as Betsy mentioned was a mediation, but before the trial date. So in theory, you have a couple months even after the case is filed, then the court's supposed to continue. That means postpone the case until the application has either been approved or denied. So the short answer to your question is yes. Are folks aware of their rights under that law? Not always, right? So, it's really important to connect folks to resources, including us, as soon as possible and as early as possible, so that folks aren't losing their homes while waiting for Raft.
Could you mention resources available to help homeless veterans find housing? I know that there are lots of them, actually, for very good reason. There are a lot of available resources for veterans. The best place that I know to go to for sort of one-stop shopping would be New England Center and Shelter for Homeless Veterans. I don't know their website off the top of my head. They're on Court Street in Boston, but they provide all kinds of housing related resources to veterans, for veterans all over New England, not just in Boston. They're based in Boston, but we have a hard stop at 3 o'clock, just to let people know. So we'll get to as many questions as we can. The general housing waiting lists they're long. My question is, what is the best way to tell an elderly person they need to wait this long? It is very difficult, especially when they're at a high risk to become homeless. Laura.
The best way to tell them?
Yep.
There isn't. I try to, when I have to tell somebody sort of the cold hard truth of the situation. I mean, first of all, it's apply for as many places as you possibly can, as long as it fits the person's needs. I have somebody who says they only want to live in South Boston, and sometimes you just can't always live in the perfect place that you want to live in. And you don't have to stay any place forever. But I think you just really have to be honest with people as far as sort of how bad the situation is, and hopefully create some sort of safety net for them. But they, don't tell them it's going to be 1 year when it really, it's going to be 5 to 10. It just doesn't help the situation.
I just want to bring people's attention to the fact that in the chat from Peter Souza, there is a resource for a hoarding specialist, seniorcareinc.org. Please check that out. Our last question, can reasonable accommodation defense be made for a person with substance use disorder?
I don't know, Betsy, what do you think?
Well, I usually try to call it something else.
Yeah.
It's very difficult to do a reasonable accommodation for someone with a substance use disorder. If they have other medical issues, you might be able to do the reasonable accommodation based on the other impairments. If substance use is the problem, is the cause of the eviction, depending on if it's selling, if it's using, if it's distributing, it could be just a very difficult case. So drug cases are really hard.
Yeah, I agree with all that. I mean, my one sentence answer would be, yes, there are arguments to make, right? Especially if substance use is a manifestation of another medical condition, which you can, shoehorn, under the federal or state definition of a disability. But obviously, as part of the plan, use of potentially illegal substances can't be part of the plan, right? So I think smoking is pretty similar, given the increased attention that has been paid, especially in federally subsidized housing recently, to pretty strict no smoking policies.
I want to thank everyone for joining us today. If there's a link to provide feedback for today's webinar. If we didn't get to your question, we'll reach out to you by email. It's been great having you all. Thank you very much for coming.